Good morning. I am Nick Bart, and I am at the firm's Chicago office. And on behalf of the firm, we are pleased to be back with you in person in cooperation with ABC to present another legal updates presentation to you. As most of you are aware, it's been the firm's pleasure to present the legal update portion of the seminar each year. And generally that has involved a discussion of recent case decisions or recent regulatory changes that are relevant to the field. This year we're going to change it up slightly, and rather than give a case discussion or a regulatory update, we're going to address a couple of issues that I think you'll find are germane to the day-to-day operation of aircraft manufacturing. Joining me on the stage are Suzanne McNulty and Stephanie Gonzalez, both of whom are partners in the firm's Los Angeles office, and both of whom focus their practice on the defense of aviation manufacturers and their insurers. Suzanne is going to start us off with a discussion of some interesting aspects relative to contract law. And I know that contracts, typically people kind of groan, roll their eyes, think, oh, here we go, here's a boring discussion, but it's not the case. And I think that you will realize that maybe even more so than some of the other topics that we have presented on in the past, this is one that it relates to your day-to-day business. And so I think you'll find it very interesting. And before I turn it over to Suzanne, just want to take a moment to remind you that one of the benefits of your participation in the ABC program is the ability to have counsel from the firm review contracts, answer contractual questions that you may have at no additional charge to you. So I'd encourage any of you to avail yourself of that benefit. And without further ado, I'll turn it over to Suzanne.
Thank you very much, Nick. I just want to say that yesterday I had the honor and privilege of playing pickleball in the over 100 degree Arizona heat. And it was actually a lot of fun. And thank you, Brian, for that, I think. Anyway, as we were playing pickleball and going back and forth, I was reminded of the back and forth nature of the Battle of the Forms. I guess I had the presentation on my mind. Except unlike pickleball, there's really no winner when it comes to the Battle of the Forms. So let's just talk about that. Some of you may be very familiar with the Battle of the Forms. Others of you probably have been lucky enough not to be on the forefront of the battle lines. The Battle of the Forms, what is it? Say you have a purchase order, say you need a part, you have a purchase order, you have a whole bunch of fine print terms and conditions on the backside of your purchase order, and then you get a confirmation or an invoice from your seller, and they have their own terms and conditions. Some are different from yours, some are additional to yours, and that's all fine and good until something goes wrong. And that's what the scenario that we'll be talking about here, how the battling forms are resolved, how different and additional terms are treated under what is called the Uniform Commercial Code, the UCC, and the best practices for avoiding the Battle of the Forms. And let me just say that to the extent that you can draft and negotiate a standalone agreement, or a long-term agreement, or any kind of agreement other than just relying on what the terms and conditions are in your forms, the better off you will be. However, acknowledging the realities of the marketplace, and because sometimes there's just time constraints and economics just don't allow you to negotiate a full-blown agreement, it just may not make sense in some situations. It might be that you just have a limited number of quantity to a one-off purchaser, and the time and expense of negotiating a full-blown agreement is just not, it just doesn't make economic sense. In which case, then, you have to know that any disputes that arise will be governed by the UCC, the Uniform Commercial Code. All right, so the model UCC, let's talk about that. It's just that. It's a model of proposed statutes that was created decades ago dealing with commercial transactions. It has been adopted in every state in the United States, in whole or in part. Some of the provisions have been adopted verbatim, while other provisions have been revised depending upon which jurisdiction you're in. Now, on top of that, you could have identical UCC provisions from jurisdiction to jurisdiction, but the courts interpret those provisions differently. So you really need to know what law applies and what state you're in. It applies to the sale of goods in the United States among US entities only. It does not apply to foreign entities. There's a whole other body of law, and there's something called the Convention of the International Sale of Goods, which applies to foreign entities. And that's a subject for another day. We won't be talking about that. So the UCC only applies to US entities. It applies only to merchants, and merchants have been defined as virtually anyone in the business, as compared to your everyday, ordinary consumer. It does not apply to services or property, and it's primarily Article 2 of the UCC that governs the sale of goods. And when you look at Article 2 of the UCC, and you take a read of it, it seems fairly straightforward, but in application, it's really not at all. And so in reading a lot of the articles pertaining to the UCC, there's a lot of descriptions, some of them quite flowery, about the UCC. And some of the legal scholars have described it as jaw-droppingly confusing, shrouded in uncertainty, the product of a miserable, bungled, patched-up job, statutory disaster whose every word invites problems in construction. So I think you get the idea. But one of my favorites is a defiant, lurking demon patiently waiting to condemn its interpreters to the depths of despair. Okay, but despair not, hopefully. We're going to try to distill it down to some basic principles so that you walk away here hopefully knowing a little bit more in terms of how you can apply the UCC to your everyday activities. All right. So to better understand the UCC, I think it's helpful to know what was in existence prior to the UCC. Prior to the UCC, the Battle of the Forms was decided using what is called the common law mirror image rule. And the mirror image rule requires the terms of the acceptance to be identical to the offer's terms. If acceptance terms deviate from the offer, it's considered a counteroffer, and no contract is formed until the counteroffer is accepted. Whew, that reminds me of the pickleball match. Really what you had was just a bunch of exchange of forms. You'd have an offer, and then a counteroffer, and then the counteroffer to that offer. You have no contract at all. You have just a big mess. Why? Because a purchaser and seller's terms are never identical. So to alleviate that problem, some jurisdictions introduce what is called the last shot rule. And the last shot rule means that the last form or document exchanged between the parties is the one that's going to govern. It's kind of silly, really, because what it boiled down to was just each party trying to maneuver itself so that they slid in the last document or form prior to performance. And the results, this ended up in a lot of arbitrary and sort of unfair results. So the UCC came in and abolished these rules. How? By finding contract formation wherever possible. Under the UCC, when the parties exchange documents demonstrating the intent to enter into a contract is formed, despite differences in standard terms and conditions. Okay, but here we have to make a distinction between what are called Dickard terms versus boilerplate terms. Boilerplate terms are sometimes known also as non-immediate terms. Your Dickard terms are things like price, quantity, and product. If you don't have agreement as to these basic terms, you just simply are not going to have a contract, even under the UCC, okay? The UCC really more addresses the problems or the issues with respect to the differences in what are the boilerplate terms, and those are things like warranty provisions, which law will apply in the event of a dispute, whether or not arbitration is required versus resolving your dispute in a court of law. And if there is disagreement as to the boilerplate terms, that's where the UCC will step in and form a contract regardless, all right? So, however, even under the UCC, there are certain things you can do so that you and not the other party's boilerplate terms will apply or will govern. And one way you can avoid that is you can expressly, this is the last part of the slide, you can expressly condition acceptance on agreement or assent to your additional or different terms. And if you do that, then a contract will not be formed, even as to the boilerplate terms. Okay, absent that, how are different terms treated under the UCC? Well, different or conflicting terms will cancel each other out and are automatically supplemented by the UCC's rules known as the gap filler provisions. And this is also known as the knockout rule. How are additional terms treated? Obviously, that's different than conflicting terms. This is where somebody's silent with respect to some terms, but somebody else has these terms in their paperwork. Well, additional terms will automatically be incorporated into the contract unless three things. Number one, the offer expressly limits acceptance to the terms of the offer. You notify the other party of your objection to the additional terms, or the additional term materially alters the agreement. So these first two exceptions provide another way you can protect yourself from the other party's objectionable boilerplate terms. You can make your offer limited to your terms only, you can provide notice that you object to the other party's terms, or if the term materially alters the contract, then a contract will simply not be formed. And it's this third exception, whether or not a term materially alters the contract, is the one that invites the most litigation. So let's talk about that just a little bit. What constitutes a material change and who has the burden? The party opposing a material change or a material additional term has the burden of proving that the term will result in surprise or hardship if made part of the contract. And those are the buzzwords. And usually hardship, surprise and hardship is defined in economic terms. In other words, if you have to comply with the other party's boilerplate terms and it results in economic hardship, then the courts will usually find that that is a material change. But there's a whole lot of case law on this, and that's not the only thing, but that seems to be the prevailing theme. And if it is considered material, the term will not form part of the contract. Okay, so what are some of the factors that the court looks to in making the determination as to whether something constitutes a material change? They'll look at the parties' relationship, their previous course of dealings and performance. They'll look at the value of the transaction, the quantity involved, industry standards, custom and usage of the trade. And just to give you some examples of what the courts have considered to be material alterations, changes to price term, that's a material alteration. Creating indemnification responsibilities, adding warranties that the offer expressly negates, changing the choice of forum, all considered in most cases to be material alterations, in which case a contract will not be formed. These last three, the jurisdictions, the courts are split, and those are issues related to contract remedies and damages, disclaiming standard warranties, and compelling arbitration. All right, so up until now, we've been talking about the battle of the forms before actual performance. And by performance, I mean what is usually understood by performance is the exchange for goods for money, all right? So what happens under the UCC if no contract is formed, but the parties perform anyway? Under the UCC, when the parties' conduct recognizes the existence of a contract for sale, but the writings between the parties do not establish a contract, the contract will consist of those terms on which the parties agree, plus any UCC gap filler provisions. All right. So let's just spend a little bit of time on the UCC gap filler provisions. You should know that they tend to favor the buyer. They provide for a broad array of implied warranties. So you need to be careful. You know, if your terms or conditions conflict with your other parties, you may get something you don't like. And you know, I'll talk about best practices at the end here, but remedies as well are rather broad-based, and there are also UCC gap filler provisions relating to liability as well as indemnification rights and responsibilities. All right, so in this short little session, let's see what we've learned in applying some of the rules to this hypothetical. Please read along with me as the facts are important, all right? Engine company sends Nozzles R Us a purchase order for the purchase of 50 fuel nozzles. Engine company uses a pre-printed PO with its standard terms and conditions on the back side. Nozzles R Us fills out its invoice, sends it to engine company. At the bottom of the invoice in fine print, Nozzles states its standard terms and conditions for sale. Being diligent, engine company checks the invoice, confirms the basic essentials, price, quantity, nozzle type, etc. Nozzles ships its nozzles, and 5 days later they arrive. Engine company inspects the nozzles upon arrival, and after several tests, finds out they're not quite up to snuff. And on day 7, after receipt, informs Nozzles R Us of this. Engine company's standard terms and conditions state it has 10 days to inspect the goods from the time of delivery at its facility. Nozzles' standard terms and conditions, of course, state something different. They say that the buyer, engine company, has 10 days to inspect the goods from the time the goods are shipped from Nozzles R Us's warehouse. So here we have engine company's is late according to Nozzles R Us terms and conditions. Who will prevail? Each has different return policy terms, right? Since the terms are different, a court would knock out both return policies and replace these terms under the UCC gap filler provisions. So what are the UCC gap filler provisions here? Under the UCC, the buyer has the right to inspect the goods within a reasonable time, and if they fail in any respect to conform, the buyer can reject the goods. The buyer must notify the seller of the rejection within a reasonable time. What a reasonable time is depends upon the nature, purpose, and circumstances of the action, including prior course of dealings, usage of the trade, and the party's course of performance. Engine company completed its inspection of the goods within 3 days and provided Nozzles R Us with notice within 7 days of delivery of the nozzles. Whether notice was delivered within a reasonable time is a question of fact that depends on the circumstances. If this is the party's first time doing business, in other words, they have no past history of dealing or performance, then courts will look to trade usage. Given the complexity of the components here, that the problem was communicated within 1 week of delivery, a court would likely be persuaded to rule in engine company's favor. All right, so best practices. Kind of get back to what I said initially here, that you can see sort of the pitfalls of the battle of forms. Sometimes you're going to get terms that you don't like if you're not paying attention to what is on the other party's forms and you don't take action. So the use of conflicting terms and conditions generally increases the risk of dispute and increases the risk of you perhaps getting terms and conditions that you don't want. So ideally, you want to ensure that if you can, put a mutually agreeable contract in place or some sort of single overarching general terms agreement. If that's not possible, then under the UCC, as we talked about, there are certain things you can do. If you're someone like Nozzles R Us, the seller, you can condition your acceptance on agreement to your terms. If you're someone like engine company, the buyer, you can expressly limit your acceptance to the terms of your offer, also known as a my terms offer. Or you can notify the other party of your objections to their terms within a reasonable time. So this means that you really have to read and pay attention to what's on the written invoices and forms and documents that are exchanged between the parties and take action under the UCC to protect yourself. But if you start performance on the contract, then no matter what you've done up till that point to protect yourself under the UCC will step in and fill in the terms upon which the parties disagree. So don't go it alone. Seek the advice of counsel. Whether you want to put a long-term agreement in place, or whether you just you need some help in drafting terms and conditions to include on a purchase order or a confirmation agreement, or you find yourself unfortunately embroiled in a battle of the forms dispute, please seek our help. We're your ABC counsel, and we are here to help you. And thank you.
Thanks, Suzanne. As you can see from those examples, it not only is possible that you end up with terms that you didn't bargain for, didn't want, it happens more frequently than you might imagine. We have claims of this nature pending right now in the office, and our clients certainly thought that they had their terms in place in advance, only to find out that they may not. So very important to try and follow the best practices, get advice up front, and read the fine print. We're going to shift gears now. As we saw in the first two presentations this morning, aviation tends to be at the forefront of modern materials, modern technologies, modern fabrication and manufacturing techniques. And the use of artificial intelligence in the aircraft and aviation manufacturing processes is certainly no different. And Stephanie Gonzalez is now going to give us some insight in the use of artificial intelligence in aviation manufacturing and some pitfalls that you need to be aware of.
Thank you, Nick. Yeah, as Nick said, we're switching gears kind of dramatically here to talk about artificial intelligence and its use in products and other applications in aviation, but really just from a liability exposure and claims perspective. So this is a new technology, but it is already being used in many different industries, including aviation. Some of you here may have some experience with it, hands-on with products that you've dealt with or handled. But we're going to take a look at the use of AI in products and how that impacts manufacturers' liability exposure. So just to start with some basic definitions, artificial intelligence, or AI, is the simulation of human intelligence processes by machines. So just like humans, the AI learns through its past experiences. It's not just an algorithm that performs as written. It's called an adaptive algorithm that continues to learn and improve with time, with past experience, and with input of data. This term used is machine learning, and that's the term that focuses on the use of the data and the algorithms to imitate the way that humans learn. So just some quick examples of AI applications in aviation, kind of some quite futuristic, but autonomous flight would be like a self-driving car, but for an aircraft, piloting by algorithm, which I know is pretty far off at this point, but will happen. Air traffic control using AI is certainly predicted. Use of AI for setting predictive maintenance schedules, and many different military applications as well. So I think the benefits of AI are pretty self-evident. It's exciting, for one. It's changing the way we think about products and about systems. It will certainly, over time, make things more efficient, safer, hopefully more accurate. And for companies, there's a great incentive to invest in this technology to give them a competitive advantage and just keep up with where this stuff is going. But it doesn't come without risks as well, and that's the liability exposure side of things. So at this point, AI, it just lacks the reasoning that a human has, and it cannot solve complex ethical dilemmas the way that a human can. And the classic example is, for a self-driving car, if a child runs out in the road in front of it, should it prioritize the safety of the child or the passengers in the vehicle? And those are decisions that are tough for humans to make too, but can be made in a split second, taking into account the context. And so currently engineers are working with philosophers to design algorithms to address these concerns, but pretty far off from being at a human level on that. Another shortcoming of AI currently is that it lacks the visual intelligence of humans. An example is a small object on the road in front of a self-driving car. Is it just a piece of trash that it can run over, or is it a dangerous object that requires that the car stop? And the most classic example of this was the well-known incident a few years ago where a Tesla self-driving car didn't see an 18-wheeler truck that was stopped on the freeway in front of it because of glare from the sun and the height of the truck, and just ran right into it at full speed, causing a fatality. So researchers are also working on this, of course. They've developed something called ImageNet, which is a repository of 14 million categorized images to improve the vision of autonomous cars. And that's just one application of AI. So you can imagine expanding that to aviation and different applications of how many images AI would need to know to operate like a human. Another risk is that AI can be unpredictable. The adaptive quality of AI means that it will continue to change over time. And as it learns and improves, it becomes more autonomous, and it can become less comprehensible to the users. And there are even instances where the programmers of the original algorithm are surprised by decisions that are made by AI down the road. One example of this is a robot Gak, who he was an experimental robot, but he was designed to be a predator robot and catch prey robots. And he escaped from his lab in England, and he crept out into traffic, which could have been very dangerous. But his programmers said that it could have been his predatory programming that made him want to go explore the world. So the big question here is, who is liable if a product that's controlled by AI causes harm, if the AI ultimately makes a bad decision? And you have to look at this now in the current traditional framework of product liability. So just a quick refresher, strict liability arises from a product defect that causes harm. And for strict liability, it's really just the condition of the product that's on trial. So the only question is, did a defect in the product cause the harm? And it doesn't matter what the intent of the manufacturer was. And typically, anyone in the chain of distribution can be held strictly liable, from the designer, manufacturer, distributor, subject to some defenses and exceptions, of course. So just definition of a product defect. A defect is an unexpected condition that causes injury. There are a few different types of defects. There's design defects, where just the way the product was designed ultimately led to harm. Manufacturing defect, where the product wasn't manufactured to spec. Can also be from a failure to warn the user of a known danger with the product. Failure to instruct a user of proper use of the product can also lead to strict liability. So applying this to AI is a little bit tricky. It doesn't fall within the traditional product mold, but a few different ways that the AI could fall within this definition is there could be a design defect with the algorithm itself. If the algorithm was poorly written and it caused the product to act in a way it wasn't intended to act, and that caused harm. Also, if the product was using AI in an application that the AI was just not ready for, and that could be the self-driving car in 2016. It lacked the visual intelligence to prevent, the accident with the truck, and so that could cause the car itself to be considered defectively designed. Another is a failure to warn or instruct if the user was not properly informed of the limitations of AI. And that's an important one. There's a lawsuit right now, Hudson versus Tesla, and that alleges that Tesla duped consumers into believing that the autopilot program was safer and required less oversight than it actually required. So lack of transparency really is what leads to that particular claim. So some defenses to strict liability that may apply in the AI context could be that the AI was not defective at the time it was manufactured. And that is a defense typically to a manufacturing defect claim. The plaintiff has to show that the defect existed when the product left the manufacturer's hands. And with the AI, with the adaptive quality a year down the road, it may be making decisions it was not programmed to make. And so it'd be very difficult to prove it was defective at the time it left production. Also, the fact that it is making these independent decisions it's a benefit, but it also could lead to exposure in this way. Another defense is that AI might not fit the traditional definition of a product, and this question was recently litigated actually last year in the Third Circuit. The state of New Jersey was using a risk assessment tool using AI to decide when to release prisoners with different data inputs. And the AI recommended releasing a particular prisoner who went out, committed a crime, and ultimately killed someone. The victim's mother sued the state of New Jersey on a strict liability theory for this crime, and the Third Circuit ultimately held that the state of New Jersey could not be held strictly liable because the risk assessment tool was not a product. It was not tangible personal property, it was not distributed commercially, and they said the information, guidance, ideas, and recommendations are not product, which ultimately that is what AI is contributing. Another interesting quality here is that the independent decision-making capability of AI is why it is used. It's its defining feature, and that really can't be, that fact alone can't be considered a defect. So if it would, again, be very difficult for a plaintiff to prove a defect if that's really the only aspect of it that ultimately caused harm. So there's alternate avenues to liability. In addition to strict liability, there's, of course, negligence, breach of warranty, and misrepresentation. So just taking a look at negligence, the traditional test for negligence is, did the actor fail to act as a reasonable person, and was the resulting harm foreseeable? So applying this to AI is very difficult. Can AI be held to a reasonable person standard? It's not a person. Can it be held to a reasonable computer standard, and what does that mean? What would a reasonable computer do? So in the hypothetical, AI caused a vehicle to collide with a pedestrian to avoid an oncoming vehicle, and is that a reasonable decision to make? So here, trying to prove negligence in this context would be very difficult. It would require very complex expert evidence, and relying on industry standards may not be possible. They're either non-existent or will be quickly outdated as the technology evolves. And AI itself cannot be considered a person, and that's going to be challenging for applying a negligence standard to it. So the alternative would be to hold the programmer or the designer liable for a, quote, bad decision made by AI. But there are potential issues here as well. Proving foreseeability would be very difficult. That is a key component of a negligence claim. And if AI, a year after it was programmed, is making decisions based on what it's learning, it may not be foreseeable to the programmer that the AI would be doing this at that time. I think probably the most important issue here is the chilling of innovation. If programmers can be held negligent to a negligence standard for years down the road based on decisions that AI is making, that would be very dangerous for programmers, and particularly in aviation where the risks are pretty great. And again, here the complexity of it and the lack of industry standards will be problematic. Breach of warranty is another way that a product using AI could be, or the manufacturer of a product could be held liable. This is a bit more limited, though. It only applies to goods or products. So if the AI is not considered a product, then that could be a defense to a breach of warranty claim in the first place. And the claim can only be brought by the purchaser of the product. So like the self-driving car purchaser could bring a breach of warranty claim ultimately for an incident. But in a lot of other contexts and industries, and particularly in aviation, there's not going to be that privity between the manufacturer and the person who's ultimately harmed. And one example currently that's come up is in healthcare, where a device using AI caused injury to a patient. Patients have not been able to recover on a breach of warranty claim because it was typically the hospital that purchased the device. So it's, really have to think outside the box with this one, and it's clear that the risks associated with AI don't fall within the traditional liability concepts that have been developed over time. And one good alternative that's been considered and would ultimately probably be most beneficial is to have a central body of experts who are just continuously monitoring the use of AI and are coming up with these industry standards, kind of like an FDA, but for algorithms. And through that, or in conjunction with that, there may need to be a regulatory paradigm that provides for some compensation for victims without having the unlimited liability on programmers and manufacturers that would ultimately chill the use of this technology. So some best practices in the meantime, and this is evolving, and so all claims that come up are going to be tested for the first time, and so it's these practices will continue to evolve as we learn more and more about how courts will be dealing with these claims. But for now, certainly allocate liability up and down the supply chains, as it's a good idea regardless. Ensuring the proper indemnities, limitations of liability, and warranties are provided for in the contracts. Like Suzanne talked about, make sure that the contract terms are clear. You don't want to have a dispute in this type of complex environment. Investing in testing and simulation campaigns and tracking of real-world data, it's a large investment to make, but ultimately will be the safest way to ensure that this technology can be used in a way that's not exposing your clients or yourselves to unlimited liability. And transparency and warnings is probably key at this point to make sure that end users or consumers understand the limitations of AI and are not expecting it to perform in a way that it just can't at this point. And that is it. Are there any questions?
I guess we were really clear on what we said.
You can't answer that one, I'm sorry.
Ask a Brit.
If you had to go to trial on one of these product liabilities cases to defend it, how do you think a jury is going to react from a understanding of the AI? I mean, our industry is already complex, how airplanes are built and fly,
Sure.
but now you're introducing AI. Do you think this is a quantum leap to find a jury to be able to understand what the programmer was thinking when he programmed this and what it did versus what they intended it to do? What do you think is it something you want to defend or you want to stay away from it?
Is that a hypothetical question? That's that's critical here. How can we expect that of a jury? It would be difficult even of a judge, to have a bench trial and to explain all of this to a judge, which is why having a panel review this stuff of experts might ultimately be the best way to handle it. But I'm sure there's going to be a few court cases that completely bungle it in the meantime. So we'll just have to wait and see how it's handled.
Tim, I think there's also a component that you have to keep in mind in that analysis, which is there's a significant portion of the population, I think, that still believes that it's irresponsible to have AI making decisions that humans should be making in their assessment, including, I think, especially in aviation. And so that's something that we would have to factor in and make a decision if we want to take a case of that nature to trial.
It seems like AI is living in a kind of legal vacuum at the moment. And I'm just wondering, are there moves afoot in the US or around the world to try and define some kind of legal framework for what is AI? Given the fast pace of development of AI, if it's not a legal person, then what is it?
No, that's a good question. Not that I'm aware of, at least in the U.S. That could be being done, behind the scenes in other countries, certainly, and other legal systems. But, particularly in the past year and a half of the pandemic, I think the legal system is just trying to keep up with, the mad, crazy backlog of cases and issues that it has, and there's not really any focus on this future technology, at least in terms of AI, of what's going to happen. And I think it's going to come, there are starting to be lawsuits, particularly with the self-driving cars, and there's some pretty famous examples of that. And as that continues to happen, there will have to be some action on that, but I think it's going to have to be forced along by the outcome of some of the initial cases.
I think Stephanie's exactly right. Unfortunately, domestically in particular, they tend not to be so proactive as to try and address the issue up front. And I think we're going to see this evolve on the heels of somebody's bad, result, unfortunately.
It's a quick question. With respect to, say, bodily injury claims, and I've certainly seen this in other aspects, whether it's workers' comp but more so other just general liability claims. We all thought we understood how the rules worked and how we should look at contract forms. And I'd say over the past decade, sort of this movement to sort of a social justice approach to how juries behave and how awards get made. How do you think about that in the context of, not only AI, but battle of the forms? We all sort of think we know what the rules of the road are, and it seems that you often don't get the results that you would normally expect. How do you think about that in the context of the aviation products space?
Well, I'll take the first part of that. That is, it's very difficult, and the UCC, I think, does solve some problems in terms of there's some level of predictability, but as you can see from the quotes that I read early on, there's also, it also invites a lot of confusion and ambiguity. And that just brings me back to what I said earlier. If you want predictability and peace of mind, the best way to go is to come up with a good set of terms and conditions, and then make sure that the party on the other side agrees with those terms and conditions. Don't just throw these forms at one another and not read them and then wait for something to happen, because that's just a recipe for disaster. And it may take an initial investment of time to make sure that you actually do have an agreement with your purchaser or seller, but it'll be well worth it down the road. And so I don't know if I answered your question, but that's sort of one way to avoid some of the uncertainty.
I think from the AI perspective, it would be most helpful to have industry standards set by experts in terms of how the liabilities will be dealt with, and how to have certain clear standards that then manufacturers can incorporate into their contracts. I think that would be most helpful. That may be pie in the sky, but it is complex, and there will be piecemeal, contracting going on in this field that will require interpretation eventually.
And I think as with any emerging technology, we're not going to fully appreciate the sympathies or lack of sympathies associated with that technology until it's fully developed. And right now we don't have either a body of case law to give us any indication of how those things are being perceived, certainly by a jury. But we can take some cues from, society's reactions to some of the examples that Stephanie put up with the Tesla case, and what I think is largely negative feedback. to the decision to have AI making decisions that people normally equate with a human role. But I don't think we have enough data set at this point to make an educated decision as to how that's trending. Any other questions? Thank you very much.
Thank you.